July wasn't paid because I discovered black mold in the building.
Your Honor,
In the building?
Yes. Throughout the building, there was black mold.
Was there black mold in your unit?
No, sir.
Before we even hear a single ruling, this case sets off alarm bells on both sides. We're dealing with a classic landlord-tenant standoff where habitability meets non-payment of rent, and those two issues collide hard in court. On one side, a tenant claiming black mold, leaks, displacement, and even the death of a pet. On the other, a property insisting repairs were timely, access was denied, and damages were caused by the tenant herself. What makes this case compelling is not just the money, it's the timeline. Rent paid on time for months, until suddenly July stops, then August, then a leak, then mold, then couch surfing, and now thousands of dollars hanging in the balance with an eviction record on the line. This is where many tenants think, if the apartment isn't livable, I don't have to pay. But courts don't work on vibes. They work on notice, proof, access, and documentation. Judges want to know when the landlord was told, how they responded, and whether the tenant followed the legal steps required before withholding rent. And pay close attention to how Judge Simpson approaches this. He's calm, methodical, but laser-focused on consistency. Every contradiction matters, every delay matters, and every emotional claim must survive legal scrutiny.
Clark Road Family Dividend Housing versus, is it Deschanel Baker?
Your Honor, we've already,
I'm sorry, where am I supposed to go?
right here.
Right here.
We're a little crowded.
All right, state your name.
Attorney Samantha Sprague, P81931, appearing on behalf of the plaintiff.
Your name?
Deschanel Baker.
All right, what are we doing?
Yes, Ms. Baker has already provided possession, so today was just an issue of money damages that were requested.
All right, and you're unable to agree on that figure, is that?
No, sir.
Correct. We do not have an agreement, Your Honor.
Not have an agreement.
Correct.
How far apart are the parties?
I haven't spoke with anyone from the property since I've turned my keys in, so I haven't been able to come up with an agreement from anyone.
Your Honor, if I
Go
may,
ahead.
the defendant has indicated that she has had habitability issues. It's my client's position that there was no habitability issues, and she is requesting damages in the amount of hotel bills that we did not receive, as well as, again, indicating a habitability issue. So we are very far off.
Your Honor,
Would you like us to speak in the hall momentarily, Your Honor?
I probably would, but hold on. What were you going to say?
Your Honor, I'm not asking for any money in return. I'm just asking for the charges to be dismissed and for no eviction to be on my record.
This is a pivotal moment, and it tells us a lot about the defendant's real priority. She's not here asking for damages. She's not demanding compensation for hotels or furniture. She's asking for dismissal and no eviction record. That matters because eviction records can follow someone for years, making it nearly impossible to rent again. From a legal strategy standpoint, this signals fear of long-term consequences rather than short-term money. But here's the problem. Courts don't erase debt or records just because someone doesn't want them. There has to be a legal basis. Judge Simpson immediately narrows the issue. He's not debating emotions, he's asking numbers. How much is owed? What portion is rent? What portion is fees? That shift tells you everything about how judges think. Sympathy never replaces accounting. And here's the tension. The tenant says she wasn't even living there during the disputed period. But legally, absence alone doesn't erase rent. Obligations. You must prove the unit was uninhabitable and that the landlord failed to act after proper notice.
Okay, I understand that last part. What is the total amount of plaintiff's claim?
Including court costs, it would be $3,055.63.
And ma'am, but the court's understanding you disagree with that because you weren't in the premises?
I disagree with that upon many factors. In the landlord's response to my counterclaim, it includes a statement that on August 6th, I denied entry to maintenance and they could see the fan because of the entryway. That is not true. I have proof that I actually asked management to meet in the leasing office to discuss my concerns, and the manager refused to meet me there. She chose to come to my apartment instead. This shows that I wasn't denying access to them. I was just asking to talk in a proper and safe environment to resolve the issues that I had, not only with just the leak and the mold and my pet dying in regards to everything going on in my apartment.
Majority of your claim, how much of that is rent?
$2,207.
I'm sorry, there was a sneeze. 2,000.
$2,207 for rent, $90 for the washer and dryer rent. Legal fees was $239.40. Additionally, there were unpaid utilities of $94.23.
Unpaid utilities.
Correct, Your Honor.
Okay.
And we do have the bills from DTE and consumers regarding that. And then, or I'm sorry, I think it's just DTE. And then the damages was the amount of $425. And that does reflect a cleaning fee. There was a secondary repair with the drywall due to tenant caused damage. And give me just a moment. And then there was a bulk fee where they had to remove bulk furniture from the unit after she moved out. And then there was also a replacement of the disposal system due to tenant caused damage.
Now we're deep into the money breakdown, and this is where cases are often won or lost. Notice how the plaintiff doesn't just say damages, they itemize everything. Rent, utilities, legal fees, cleaning, drywall, disposal replacement, bulk removal. That level of detail strengthens credibility in court. The tenant immediately pushes back, claiming nothing was wrong when she left. And that's a classic dispute. But here's the legal issue. Photos, invoices, and third-party repair records usually outweigh personal testimony. Judges see hundreds of cases where tenants say, "It worked when I left." Documentation decides which version survives. What's especially damaging is the allegation of secondary damage. The landlord admits they didn't charge for the initial drywall, only for a second repair allegedly caused afterward. That distinction is critical because it frames the charge as avoidable tenant conduct, not landlord neglect.
Yes, upon me moving out, there was nothing wrong with the apartment. With me leaving, the disposal working.
Hold on, man. Were you in a hotel or not?
I was staying at family, friends, and relatives. I'm currently couch surfing. I don't have anywhere to stay.
Well, okay. I mean, during this period of time, were you in the unit?
During this period of time, I was not in the unit. I was staying at a family friend's house.
Had you notified the landlord of that
Yes, I did.
in writing?
Yes.
You have
I
a
submitted
copy of the
them.
writing?
I submitted a paper in writing stating that I would not be paying rent,
Okay.
that I wasn't staying in the
I
property because
understand what you're telling me.
Mhm.
Do you have a copy of what you gave to the landlord?
yes.
All right. Have you shown the landlord that?
Yes, Your Honor. The defendant also refused entry for repairs during that time without her being present. And so our argument is that she failed to mitigate the damages. Additionally, repair was made that same evening to the leak in the ceiling that was caused by the HVAC system above her unit. So it had leaked through.
This is where the legal concept of mitigation takes center stage. Landlords are required to respond reasonably fast to serious issues, but tenants also have obligations. If repairs are offered and access is restricted, courts often side with the landlord. The plaintiff lays out a tight timeline. Leak reported late at night. Maintenance responds immediately. Fans installed. Professional cleaning within a week. Repair completed by the 19th. That narrative directly counters the claim of neglect. Judge Simpson zeroes in on one thing: agreement. He doesn't care about tone, frustration, or misunderstandings. He cares whether both sides agree the leak was addressed. And once both parties admit repairs were made, the argument shifts from "nothing was done" to "it wasn't done how I wanted." Legally, that's a much weaker position. Courts don't require perfection, only reasonable action. Viewer question: should landlords be required to give exact repair schedules, or is prompt action enough?
She called in sometime after hours. By 10:30, 11 o'clock that evening. We have maintenance here on site to provide testimony that they provided immediate repairs, including fans. Within a week, they had a professional carpet company out there that provided additional remediation, including repair or cleaning the couch and the rug. And the repair itself was completed by the 19th.
Your Honor,
And this occurred on the 5th.
Your Honor, that's not true. On the date I was at work that they came to repair the apartment, Maintenance
Well,
entered my home.
ma'am, let me ask you this. Did you let them into the unit
Yes,
to make the repairs?
yes. The date that she mentioned, I was not home. The maintenance guy called.
Are you disputing that they made the repairs?
No, I'm not disputing that they made the repairs. They did enter my home and make the repairs
Okay.
on the 19th after the leak happened on the 6th. They did not reach out and let me know when they were supposed to come. I had got no notification when the repair was supposed to be made. I had went up to the office multiple.
So, but why would that
I'm sorry.
matter?
What's your question? Why would what matter?
You called in a leak. They came and fixed it. We're all in agreement on that.
They did not come. I called in the leak. No one communicated with me. I called in the leak the night that it happened. Two employees came and he pulled out where the leak had came from because they said that they had not fixed or changed the filters out. The filters were supposed to be changed every 6 months. I had been living there for 9 months and
Okay,
nobody
that's
came.
fine, but that you called in a repair. What you're telling me is that they came out that night, right?
They came out that night and put a blower in my house and just told me to leave it on the ceiling and on my furniture that had been ruined. Yes,
But
the leak was not fixed that exact night.
okay, but they don't necessarily have to fix it. They tended to what your complaint was, right?
Correct.
And then at some point within those next 2 weeks, they fixed it. You would agree, right?
No, it was not within 2 weeks.
I thought the 16, 19.
Your Honor, the drywall took additional time.
The drywall.
The drywall took additional time.
But the leak was fixed.
The leak was remedied. And then once the leak was confirmed, they did wait, I believe, a couple of weeks to confirm that the leak was finally
Was
fixed.
final.
And they had
then
a
the
third
drywall.
party, correct, and they had a third party drywall company come out to provide repairs. At that time, once the repairs were complete, the tenant did, or the defendant did come back home. There was wet paint from the repair, and she proceeded to poke a hole back through the ceiling. That is where the charge came from. The property did not charge her for the initial drywall. They charged for the secondary repair because she poked a hole in, alleging that it was moisture from the leak that had not been an issue for several weeks.
Did you do that?
Maintenance had previously told me that if a
Okay, hold on. Now, you need to answer my question. Did you put a hole back in the drywall?
This exchange is brutal because Judge Simpson asks a yes or no question and the answer doesn't fully land. The tenant says it wasn't intentional, but intention isn't the legal standard here. The question is whether her actions caused additional damage after repairs were completed. The landlord's photo evidence becomes crucial. A hole over a doorway with no furniture beneath it directly contradicts the explanation given. When physical evidence conflicts with testimony, judges almost always defer to the evidence. What's also happening here is a credibility assessment. Every time explanations shift or become complex, confidence erodes. Judges look for consistency. The more qualifiers added, the more doubt creeps in. This is a hard lesson. Even when you feel justified, improvising repairs yourself can backfire legally. Audience question: do you think her explanation makes sense, or does the photo change everything?
No, I did not intentionally put a hole back in the drywall. I allowed the water to flow into a bin instead of on my couch.
After they made the repair?
Yes,
What date was that?
19.
Your Honor, we have a photograph of the hole in the ceiling that indicates it's over the door. There's no couch underneath that photograph.
Your Honor, the hole where the leak had happened, my furniture was there. They had, in their counterclaim, said that I denied them entry and that I damaged their property. I was just trying to get my problems resolved so that I could leave the property voluntarily. I was reaching out to compliance and upper management to
This
discuss.
rent is for what period?
It is for the period of July, August, and I believe part of September.
I moved out September 17th, right after our first hearing.
And the leak occurred when?
August 6th.
So why wasn't July paid?
July wasn't paid because I discovered black mold in the building.
Your Honor, we
In the
have,
building?
Yes. Throughout the building, there was black mold.
Was there black mold in your unit?
No, sir. There were immensible other problems that I was facing while living there that contributed to me not paying rent.
Tell them you weren't paying rent?
Huh?
in August, we received, or my client received notification in August after the repair had been partially made and the drywall was pending, indicating she was not.
How long, when did you move in?
I moved in January 24th of
So
2021,
January,
but they,
hold on, January, February, March, April, May, June, you paid rent.
yes, on time every month
So the black mold came in when?
in July.
All of it?
Yes.
It just appeared.
The black mold, it came from an apartment that was also leaking water on the first floor. There was also an apartment leaking
So
water
the
on the
black,
second floor.
hold on, the black mold just started to exist in July?
The black mold did not just start to exist in July. It's when I became aware of the problems that not only I was
So when
facing,
you
but the other
didn't pay
tenants.
July, did you tell them this is why I'm not paying my July rent?
No, Your Honor.
Then you've got a problem. Even if true, which I have my doubts.
This is the turning point of the case. Judge Simpson makes it clear. Even if the mold claims were true, the tenant failed to notify the landlord properly before withholding rent. That single admission, "No, Your Honor," is devastating. In landlord-tenant law, notice is everything. You cannot unilaterally decide not to pay rent without formally informing the landlord of the reason and giving them a chance to fix it. Courts protect process, not assumptions. The judge openly expresses doubt, not hostility, but skepticism. That signals risk. When a judge starts doubting factual claims, settlement suddenly becomes the safest exit. This is why Judge Simpson encourages hallway negotiations. He's essentially saying, you don't want me deciding this. Viewer question, should courts be stricter about tenants withholding rent without legal guidance?
So what I'm going to suggest you do, and then is why don't you take a moment to talk
Yes, Your Honor.
and see if you can resolve it. I will let you know, young man, I'm seeing certain problems with what you're telling me regarding any type of solution to this in terms of the monetary amount. But we can all have our positions. I'd suggest that you talk with counsel and see if you can work it out. If you can't, then I'll take you back and we're going to work it out.
Okay.
Thank you, Your Honor.
But I don't know that you really want to talk to me today. But I'm always happy to talk to you. Thank you.
Thank you.
Thank you, Your Honor.
I haven't called that one.
Excuse me, Your Honor. I offered the plaintiff, I'm not exactly sure, $2,000 within 2 days. Do you know?
Did you propose that to them?
Yes.
And what did they say?
They let, I'm not exactly sure what I'm supposed to
What do you mean?
do. Should I go out there and try to talk to them, or should I just wait here and come back and decide if they want to talk to you?
So you have an offer to make to them of paying
I offered
$2,000 in a couple of days? Go see what they say. I'm never doing this again. Okay. Buck Road, family dividend versus Baker. I have before me a consent order for conditional dismissal that indicates that the defendant would agree to pay $2,000 on or before 5 p.m. on October 30th, 2025. No personal check, only certified funds. Defendant pays on or before October 30th, 2025. Plaintiff will waive the remaining balance.
This is the deal, and it's a big one. Pay $2,000 and more than $2,500 disappears. No trial, no judgment, no prolonged risk. But there's a catch. Miss the deadline, and the full amount snaps back instantly. Judge Simpson ensures absolute clarity. No confusion, no loopholes. Certified funds only. Deadline locked. This protects the plaintiff while giving the defendant a lifeline. Legally, this is a balanced resolution. The landlord recovers guaranteed money. The tenant avoids a crushing judgment and potential eviction consequences. Settlements like this happen when both sides realize uncertainty is worse than compromise. Audience question: would you take this deal or risk a full ruling?
That's basically the court's full understanding, except to make it clear that if you don't pay that, then plaintiff would be entitled to a judgment of the full amount of the, including cost of $3,055.63. You understand that, ma'am?
Yes, ma'am. Yes,
Are there any other questions that you may have regarding this conditional order dismissal?
no, sir.
All right, so you understand everything?
Yes, sir.
Thank you, folks, for resolving it. I will sign off on that. Ma'am, I do have to advise you, since you are here unrepresented by counsel, you have 3 business days to think about this. If you think that there's some legal reason on your part or some right you didn't assert, you'd have to file a motion with the court within that time frame. You understand that?
Yes, sir.
Doesn't mean that I would grant it. You have that time to think about it, file that motion. You understand that?
Yes, sir.
All right, very good. Ms. Baker, let me say something to you. Sometimes you can come in with the greatest of all intentions, but I think you could have had this resolved a whole lot earlier had you maybe proposed that to council and kind of worked it through, realizing what your potential liabilities may have been in this case. Okay, so if nothing else, I hope not only with regard to a satisfactory settlement of this, that you learned something else from this.
Absolutely.
This case ends not with a dramatic ruling, but with a lesson, and that's often how real courtrooms work. The tenant avoided a full judgment, but only after facing serious legal exposure. The landlord recovered money, but not everything they sought. The key takeaways are clear. Habitability claims must be documented, rent withholding requires proper notice, and communication failures can turn manageable problems into courtroom battles. Judge Simpson's message is simple: understand your obligations before positions harden. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.